May I place this order, Mills?
Please do.
Paragraph 3, Mills. In 2016, the School Service Commission in West Bengal conducted selections for recruitment to 4 categories of posts. Assistant teachers for class 9 and 10, assistant teachers for class 11 and 12, non-teaching staff of the group C category, and non-teaching staff of the group D category. Notification for the state level selection test was issued on 16th February 2016. An OMR based written examination was held on 27th November 2016. The final panel for candidates for class 9 and 10 was published on 12th of March 2018. The merit list of empaneled candidates was published on 28th August 2018. Candidates joined as assistant teachers in or about January and February 2019. A batch of petition was instituted before the High Court challenging the selection process of 2016. The selection process for assistant teachers was governed by West Bengal School Service Commission. Selection for appointment to the post of teachers for class 9 and 10 in secondary and higher secondary schools, rules 2016. Likewise, there are rules governing the selection to assistant teachers for class 11 and 12 and also of 2016. The selection for Group C and Group D non-teaching posts is governed by West Bengal School Service Commission, rules 2009. The writ petitions before the High Court were instituted in 2021. From time to time, interim orders were passed by the High Court annulling the appointments on the ground that appointments were made illegally. The appointments were assailed initially before the division bench of the High Court, and ultimately the dispute traveled to this court. By its order dated 9th of November 23, this court held that the direction of the High Court for the termination of services of candidates at the interim stage, even before the final disposal of the petitions, ought to have been avoided. This court, while dealing with a batch of petitions directed in Achintya Kumar Mandal versus Lakshmi Tunga, that all the issues relating to the appointments of 2016 should be examined by a division bench of the High Court, and accordingly, an order of remand was passed. The issue of maintainability of the petition was kept open. The order of remand has resulted in the impugned judgment of the High Court. The High Court has held inter alia that all appointments made in the selection processes involved were violative of Article 14 and 19 of the Constitution and are therefore null and void. As a consequence of the judgment of the High Court, approximately 25,000 appointments would stand to be set aside. During the course of the hearing of the cases before the High Court, there was a direction to the Central Bureau of Investigation to conduct an investigation in regard to the alleged acts of criminal wrongdoing arising from the selection process. The order dated 9th November 2023 directed the CBI to complete its investigation within 2 months and to submit a report of the High Court. In the meantime, this court directed that the appointments which have been made shall stand protected for a period of 6 months to enable the division bench to adjudicate upon the matter. Before the High Court, as indeed before this court in the earlier proceedings, a fundamental issue which arose for consideration was in regard to the admissibility of the OMR sheet images which have been recovered by the CBI. The court noted that the investigation by the CBI has yet to be completed. The admissibility of the OMR sheet images being in question, this court observed that the question of the exercise of power in relation to discovery of electronically stored OMR sheets implicated serious allegations in regard to manipulation of records. Having regard to the number of persons who are likely to be affected by the outcome of the proceedings, it was considered appropriate to remand the proceedings back to the High Court for final decision on the writ petitions. Before dwelling further on the ultimate directions which have been issued by the High Court, it would be necessary to note at this stage that 3 reports were filed by the CBI after the remand of the proceedings. The impugned judgment of the High Court has dealt with the reports of the CBI. it would be necessary at this stage to make a brief reference to the report dated 5th February 2024, which is the final report which was filed before the High Court. The report of the CBI notes that the West Bengal School Service Commission had awarded a work order to a company by the name NISA Communications Private Limited for scanning and evaluation of the OMR sheets pertaining to the selection test for each of the 4 categories. The scanning of the OMR sheets was undertaken by the company at the office of the SSC. It further emerges during the investigation that the company which was awarded the contract by the SSC had further assigned the work of scanning the original OMRs to an entity by the name of Data Scantech Solutions, Noida, which was present at the premises of SSC for completing the scanning work. According to the CBI, after completing the scanning, the processed data in the form of scanned images of OMR was handed over by Data Scantech to NISA Communications in the digital form, leaving the original hard copies of the OMR sheets in the office of the SSC. According to the CBI report, the SSC handed over the answer keys for all subjects to NISA Communications Private Limited for evaluation of the OMR responses. CBI seized the server database of the SSC during the course of the investigation. On 15-16 September 22, 3 hard disks were recovered from the residence of a person by the name of Mr. Pankaj Bansal, a former employee of NISA Communications Private Limited at Ghaziabad. Certificates dated 19 September 22 under Section 65, capital B of the Evidence Act were obtained from Mr. Pankaj Bansal. During the course of the investigation, data files containing scanned OMRs, among other things, were seized from Data Scantech Solutions. The report of the CBI contains the following observations in para 12 and 13 of the report. Para 12, that a similar exercise of matching the data available on the hard disk of Pankaj Bansal with the data seized from the commission was done during the course of investigation, and it was found that there were mismatch between the two, inasmuch as the written marks awarded to candidates as available on the server of the commission had been increased to qualify undeserving candidates. This mismatch establishes that manipulation in marks of written examination in the case of many candidates was resorted to, and such candidates were identified. The comparison of these actual genuine OMR marks with the OMR marks available in West Bengal Service Commission server shows that there is a manipulation in 952 numbers of candidates of class 9 and 10, 907 numbers of candidates of 11, 12, 3481 numbers of Group C candidates, and 2823 of Group D. That during the course of investigation, several emails were found to have been exchanged between the accused officials of the commission, certain private persons and officials of NISA. These emails contained lists of candidates whose OMR marks were found to be increased in the server of the commission. Besides these, the emails have been exchanged between the staff of NISA themselves, containing the manipulated data of candidates. This shows the complicity of officials of Mrs. NISA in this conspiracy. The above noted investigation by the CBI indicates that it has found a manipulation in respect of 952 candidates for the selection process of assistant teachers for class 9 and 10. In the case of 907 candidates for class 11 and 12, 3481 candidates.
This will indicate that the marks were increased when they were uploaded in the server compared to the written examination.
That's right. So
that's all. That clarification is just we wanted that.
Yes. Apart from the above report of the CBI, the impugned judgments of the High Court contained in para 240 a reference to the fact that SSC had submitted a statistical report of the 4 selection processes tabulating the alleged irregularities. The tabulation is reproduced below for convenience of reference. So, Lordship will see that with regard to assistant teacher, the irregularity percentage is 8.5. Assistant teacher 11-12 is 14%. It is larger in case of Group C and Group D. The High Court has also noted that in response to its queries, the SSC had submitted details of the recommendations which were made by it in respect of the 4 categories and the number of appointments issued by the board. The figures submitted by the SSC indicated that the actual number of persons who were appointed by the board was in excess of the recommendations made by the SSC to the following extent. Assistant teachers, 1539. Assistant teachers, 912, 199. Group D, 669. And Group C, 416. On the basis of the data which was submitted
No,
before it,
just 1 minute over here. The recommendations for group D was that this is the enhanced number above that.
yes,
That is enhanced number above the figure of, say, in the case of 11,610, 5596, 2037.
Yes. Yes, sir.
Okay,
Only for.
yes, please, continue.
and the SSC had submitted details of recommendations which were made by it in respect of the 4 categories and the number of appointments issued by the board. Figures submitted indicated that the actual number of persons who were appointed by the board was in excess of the recommendations made by the SSC.
Okay,
So this is the another fault, my lord, that some more people.
yes, please.
On the basis of the data which was submitted before it by the SSC, the High Court has observed in para 241 that the illegalities admitted by the SSC cannot be said to be within tolerable margins in a selection process of a large magnitude, and that the SSC itself did not discount the fact that the possibility of the existence of further illegalities may still exist. The High Court further noted in para 273 that the SSC had not been in a position to state that it had checked all the records so as to be definitive about the number of illegalities, and the state government had also accepted that there were widespread illegalities in the selection process. On 19th May 2022, the government of Bengal in the school education department issued an order creating 6861 supernumerary posts of teachers and non-teaching staffs for absorbing the wait-listed candidates, and directed that appointment letters to such wait-listed candidates shall be issued in terms of the recommendation of SSC, subject to the outcome of the pending litigation before the High Court. Now, this will be one of the issues, Lord, which I am concerned with, which I'll elaborate later, Lord. During the course of the hearing, this court has been informed that the petitions under Article 226 of the Constitution, petitions have been instituted before the High Court to challenge the order of the government creating the supernumerary post to accommodate the wait-listed candidates. By an interim order, the government order creating the supernumerary posts have been stayed.
So what is your stand? You want the stay to be vacated or what?
No. We did not appoint. What the High Court has done in this case is that separately, Lord, independent of these illegalities, they have put a question, Lord, to the state as to why these supernumerary posts were created. So with regard to that also, they have, Lord, issued a direction that a CBI inquiry should be done, how this order was passed and the entire.
Okay,
So with regard to that direction alone, which your lordships have stayed in this by this order. I'm not saying we did not appoint anybody except one candidate, which High Court had directed on humanitarian grounds. In this backdrop, the High Court by its impugned order has, while setting aside the appointments, directed that the OMR sheets available in the 3 hard disks must be uploaded on the website of the Selection Commission. Persons who had been appointed, A, from outside the panel, B, after expiry of the panel, and C, against the submission of blank OMR sheets, must return all the remuneration and benefits received by them to the state exchequer, together with interest at 12% per annum, failing which the outstandings would be recovered as arrears of land revenue. CBI shall interrogate all persons who had received appointments beyond the panel after expiry of the panel and after submitting blank OMR sheets if necessary by undertaking custodial interrogation. CBI shall undertake a further investigation with regard to persons involved in the state government who had approved the creation of supernumerary posts to accommodate the illegal appointments, if necessary, by conducting custodial interrogation. And 5, the SSC shall undertake a fresh selection process as a consequence of the vacancies which are declared on the setting aside of the appointments. Other consequential directions have been issued. Primary submissions which have been urged during the course of hearing by counsel appearing on behalf of petitioners fall under 4 broad heads. 1. The data on the basis of which the High Court has set aside the appointments of nearly 25,000 persons, including assistant teachers and those appointed to non-teaching Group C and Group D posts is suspect. The foundation of the exercise is the certificates under Section 65 capital B issued by Pankaj Bansal, a former employee of NISA Communications Private Limited, from whose possession the 3 hard disks were seized. In a selection process having such a large magnitude, cancellation of the entirety of the selected list, select list would be a matter of the last recourse. Where a segregation of the tainted candidates is possible, only such appointments should be directed to be discontinued. 3. The above consideration must apply to A fortiori in a situation where the petitions were filed nearly 3 years after the appointments were made. The directions to set aside the entirety of the appointments would have serious repercussions to employees who have served the state. 4. Where the appointments which are tainted are capable of being identified, it was manifestly unjust for the High Court to set aside the entire process. On the other hand, it has been urged on behalf of the respondents who have supported the judgment of the High Court that both the SSC and the state government were not in a position to state the possibility of further illegalities can be ruled out. When a systemic fraud has vitiated the entire process, the High Court was justified in setting aside the entirety of the selection process. The submissions which have been raised on behalf of the petitioners would merit further consideration. The certificates under Section 65 capital B of the Evidence Act were issued as the CBI report notes by Pankaj Bansal, who is a former employee of NISA Communications Private Limited. The legitimacy of the certificate which have been obtained from the above individual would prima facie go to the root of the data which forms the basis of the judgment of the High Court to set aside the entirety of the appointments. From the material which has been placed on the record before the High Court by the SSC and the CBI during the course of its investigation, a further issue which would merit closer analysis is as to whether appointments which suffer from taint can be specifically segregated. If such an exercise is possible, it would be unfair to set aside the entirety of
Main issue, in fact, let's be very clear, this is the main issue.
that is the main issue, Murad, except for the state which is concerned with that part.
That's the main issue.
Yes.
One issue is the material on the basis of which the finding is recorded.
But-
There's only one certificate
But
that.
I must tell your lordship, Lord, that there is a group of petitions, Lord.
So are you supporting the
So
proposition?
I'm not supporting it, but yes,
No, 1 minute.
the
Is
state
the
is
state of
supporting
West
the.
Bengal supporting the proposition? It's not possible to segregate the taint from the.
No, the
untainted?
state is saying that supporting this segregation, Lord. We are saying that it can be, because CBI has not given several reports.
Okay, that's the
And
main
therefore-
issue. So that's the reason why I pointed it out. Please focus your arguments on that.
Yes. But there are a group of petitioners who are questioning, Lord, the entire judgment, Lord. Based on
Maybe, they
65.
can be. They
Yeah.
can.
The court cannot be unmindful of the impact of setting aside of a large complement of assistant teachers who have been recruited for both classes, which would be the consequence if the impugned judgment were to be upheld as it stands. Assuming that a segregation is possible, the court would have to determine the modalities which would be followed for that purpose. At this stage, the court must be guided by the fact that by its order dated so-and-so, this court had protected the appointments which had been made subject to the direction to the High Court to expeditiously dispose of writ petitions, bearing in mind that notice is issued. Then some interim protections were given, which you'll also find in para 34.
Yes,
In the meantime, an interim protection which was granted by this court by its order dated 9th November is continued, subject to the express stipulation that any person who is found to have been appointed illegally and is continued as a consequence of the present order shall undertake to refund the entire amount of salary which may be paid between the date of this order and the final judgment of this court.
Just one clarification. This interim order also inures to the benefit of those where the numbers mentioned,
Illegalities have been specifically found.
yes.
Yes,
16
that
and
is covers
17,
them also, they are also continued, so but with this stipulation that they will have to
they
refund
have to
everything.
cover 16, if those covered by 16, in paragraph 16 and 17 is also, they're getting benefit of this interim order.
Yes,
Okay.
and they are in fact working also.
17.
Okay, yes, please.
Then the investigation by the CBI, which has been ordered by the High Court in clause 7 of its operation directions, will continue, but no coercive steps shall be taken. 36, this is where which state is concerned. The High Court has by its impugned order directed the CBI to investigate the creation of supernumerary posts at all levels of the state government. This court by its previous order directed that no precipitate action would be taken in pursuance of the direction contained in clause 8 of the operative directions of the High Court, which is reproduced below, which is this, my lord, that CBI will undertake further investigations with regard to the persons involved in the state government, approving creation of supernumerary posts to accommodate illegal appointments. If necessary, CBI will undertake custodial interrogation of such persons involved. Now, this expression to accommodate illegal appointments is incorrect. The order doesn't say that. It says it will to accommodate waitlisted candidates because there were already reports of Justice Bag's committee, etc., pointing out illegalities. So the state was worried a lot about the vacuum which will be created. So they created supernumerary posts for appointment from the waitlisted, and that is also subject to the approval by the High Court. And in fact, no appointment has been made. So this blanket direction saying that you investigate everybody who is right from the officers, right up to the cabinet, the posts have been created. And with custodial interrogation and all that. So our submission is that this division bench went too far ahead, which was unnecessary. Then para 37 stated that no appointment whatsoever has been made in pursuance of the order of the state government dated 19th May 2022.
You
Which
may therefore divide your arguments into two parts. One is with regard to segregation, and the other is with regard to the direction given in terms of paragraph 8.
8. So
You
we
can
are
divide your
concerned with
arguments
this.
into two parts. First, you deal with the segregation part, and then you can deal with 8.
Now, as has been stated by your lordships in this judgment order which I have read out, and which is not disputed, that one, there was Justice Bag's committee constituted to investigate the irregularities. Then brought the CBI investigation when the OMR sheets were recovered from NISA. Then they were handed over to the selection commission. They also submitted their report.
Okay, what we can do is, we can now go to the impugned judgment. Why did they say that it's not possible
Yes.
to segregate?
That's right.
But may I add one aspect, my lord? I appear for the commission. My lord, the commission has filed its written submission to the effect, my lord, that we support the segregation and that it is possible. Secondly, my lord, after this interim order was passed, we have carried out the exercise and we have filed an affidavit on 2nd of August of this year, my lord, indicating name-wise the persons who we believe are, my lord, capable of being segregated, and my lord, the rest can be saved because there is 25,000.
That being there, no, let's first see the reason.
Yes.
Kindly have page 255 of the impugned order. In fact, please have 252 minutes. Because one of the issues was whether these OMR sheets recovered from NISA's officials, etc., not is reliable, it should be proceeded, because that is the
No,
foundation.
1 minute. We'll go to that later. You start this.
No,
Start
this,
this.
this is important. I'm not going into that issue.
Mr. Dwivedi, I'll tell you the reason why I'm saying so.
Yes, ma'am.
There's a misconception about 65B. 65B is only a mode of proof. The evidentiary value which will attach to a particular document, the weight will be attached to a particular document depends upon not the mode of proof alone, though they're connected, but to several other factors.
So I'm not going
So
into.
let's not go into that. So the second part, when we deal with the second part, it will obviously answer the first part.
No, I'm not at all not going into that issue because I'm not questioning, state is not questioning the authenticity and all those of the OMR sheets.
There's a difference between the two. There's a huge difference between the two. Anybody issuing 65B certificate is only a mode of proof.
So what I'm
It's
trying.
it's not dealing with 65B doesn't deal with and say what evidentiary value will attach to that document.
All that I'm trying to point out is that in this paragraph 307, you'll actually just note it, I will not read it.
Okay,
What-
we'll come to that. Let's first read the reasoning. Therefore, I
So
said.
High Court, foundation of my submission is based on this, namely, the High Court says that these are authentic, reliable and everything. I am proceeding on that foot. I'm not questioning this.
Okay, if you want to
I'm
read, we
leaving
can
it-
read that. If you want to, after having given that caveat, if you want to, please do
So
that.
just have at page 253, last 5 lines. I'm not questioning this finding for the same. High Court says at the bottom of 252,
You
factual,
start from 307.
yes, the certificate dated 16th September 2022 issued by Mr. Pankaj Bansal relates to the data contained in the 3 hard disks adherence to requirement of section 65B in the facts and circumstances of the present case has to be adjudged on the conduct of the parties to the proceedings. All the relevant parties have admitted the contents of the 3 hard disks and acted on it without any demur. The Selection Commission has acknowledged manipulation illegalities in the recommendations and withdrew, cancelled the same. State has decided that the cabinet.
I take it that OMR sheets originals have not been recovered.
No,
They have been destroyed.
they were destroyed because.
Please, they have been destroyed. So original document is not available.
Not available because petitions were filed after two years long gap, so they were not available, which is correct. Now, all I'm saying is, and I'm relying on this, that once the High Court relies on the authenticity, valid.
Mr. Dwivedi, there is a difference between the two. 65B certificate will only say that what is downloaded from the hard disk into the hard form is what is stated or loaded in that server or the hard disk.
That's right.
What was loaded on the server, whether it's a true and authentic copy, is never given by 65B.
No,
That is never given by 65B.
no,
That's a question of evidence. There's a difference between the two. I'll give you one simple example. The call record details which we get are downloaded from a server. That downloaded is first captured when the calls are made. Then there's a blockchain effect. You keep on changing. When a person gives that certificate, he gives a certificate that as I downloaded from the server, this is the data which is there. But he cannot vouch for whether there was any manipulation or change in data.
or before it was downloaded. That's all. I'm not questioning. Others will, learned counsel will address on that note. I'm not going into 65B. What I'm saying.
Please wait for your turn.
I'm making a very limited point here that High Court has in the last three lines, factum, validity, legality, sufficiency, authenticity of the data has been proved by the conduct and actions of the relevant 12 authorities subsequent to the seizure of the three hard disks and after CBI had shared such data with the relevant authorities. So after recovering, then it was shared with the commission, other authorities, and therefore finally, my lord, the High Court feels that this authority, these data can be relied upon to adjudge, my lord, whether there has been enhancement of marks in it or not. All those findings are based on the first prima facie finding that this is authentic and we can be proceeded with. This is all the limited thing which I wanted to point out. Now kindly have, my lords, paragraph 312 at page 255. In the factual context of the present, sorry.
Thing we want to know,
Yes.
is there any rule or prescription in the, that when OMR sheets should be destroyed?
Yes, 1 year.
1 year is.
1 year. Okay. We are asking a question, Mr. Dwivedi, everybody's wanting to answer.
Anxiety, brother.
Yes, please.
At page 255. The bottom para 312. In the factual context of the present proceedings, we have three options to explore, namely, dismiss the writ petitions on the ground of maintainability. 2, explore the possibility of segregating the valid appointments from the illegal ones. 3, set aside the selection made in the selection process in its entirety.
Now, as far as second option is concerned, we need not go through the judgments. We know the case law. So we can skip that.
Yes,
Segregation is the second option.
that's all right. The judgment cited
We know the legal position ratio. Why should we read those?
only the earlier judgments.
Yes.
In the
But we have given
That's
it
told.
now.
Come to,
Para 320. Para 320.
yes, please.
The authorities noted above have observed that cancellation of a selection process without appointment being given therein stands on a different footing than a selection process where appointments had been granted. In the second category, courts must shift the grace from the shaft if possible. In the event it is impossible or highly improbable to shift the grain from the shaft, then the court may venture to cancel the entire selection process. Prior to embarking upon such an exercise, it must be satisfied that the selection process was tainted on the basis of cogent materials. There must be sufficient materials gathered through a thorough investigation that there has been illegalities in the selection process. The appointees had benefited out of the illegalities and were a part of it, and that the appointments made were contrary to law. In respect of the four categories of the selection process involved, written examination has been held. Written examination was in the form of OMR sheets. Original OMR sheets have been destroyed by SSC. Mirror image of the destroyed OMR sheets was required to have been preserved by SSC. CBI had seized the server of the SSC and did not find mirror image of such OMR sheets in the server of
Is
SSC.
this factually correct?
Factually correct.
Is this factually correct?
Mirror image. Yes.
Was mirror images of the Omar sheet preserved by the SSC?
Not preserved and not required. to be preserved.
One minute. That's the second argument, but they were not preserved.
SSC is an authority within the meaning of Article 12 of the Constitution and have been enjoined with the task of undertaking the selection process. Last report of the CBI has stated that SSC appointed Messrs. NISA for the purpose of scanning and evaluation the OMR sheets. Messrs. NISA had engaged another organization, Data Scantech, to do so. It is unclear as to whether the new agency had merely scanned the OMR sheets or was instrumental in evaluating the same also or not. Chairman of the SSC, in response to a query, the court has stated that he was not aware of the engagement of Data Scantech in the selection process, and that in fact he became aware of such name only from the court for the first time. No material has been disclosed as to who authorized Mrs. NISA to engage Data Scantech or that such instrumentality was lawfully engaged by SSC.
So what is being held is this, actually, that SSC did not keep a mirror image with them of the OMR sheets. They had engaged NISA to undertake the evaluation of the OMR sheets. And NISA in fact gave it to
Data Scantech.
Data Scantech. They also did not do it.
Yes.
The three disks which were recovered are from NISA or from Data Scantech? From
NISA.
Data Scantech,
NISA.
from NISA. NISA must have got that data from Data Scantech because they did it.
No, NISA took the data in its computer, then NISA must have given a copy to
Correct,
them for
correct, correct.
So
So 1 minute, please. So the data scanning or the OMR sheet scanning is done by Data Scantech, as per you,
as per the finding, yes.
as per the finding given. And that data was then, or the hard disk with regard to that were given to NISA because NISA is the authorized by the SSC to undertake that. Yes, please.
Significantly, it is the claim of SSC that scanning of the OMR sheets had taken place at its office. If that be so, then SSC had knowingly allowed another organization to scan the OMR sheets, namely Data Scantech, who was not authorized at all. These raise questions as to the integrity, sanctity, and validity of the entire selection process and giving to the root of the selection process, the evaluator of the selection process had been selected through a process which at best rooted in mystery, if not downright illegal. Then the conduct of the evaluator is such that it affects the validity of the process of evaluation itself. Significantly, Mrs. NISA had been appointed without an open tender. SSC had selected Mrs. NISA ostensibly on the ground of its being the lowest tenderer from amongst a chosen few who were asked to participate. The parameters qualification required to participate remains undisclosed despite a request being made in court to SSC. No explanation has been provided by SSC in course of hearing as to how and why such a course of action had been undertaken in identifying the instrumentality who was to scan and evaluate the OMR sheets. So,
1 minute. That's the question because you are also supporting that it's possible to decipher tainted from untainted. You see, the original paper is the OMR sheet. That's a fact, that's a primary evidence.
yes,
If any manipulation is done on the main evidence or main paper, it will be only visible in the OMR sheet. OMR sheets, normally we have pencil marking, if I'm not mistaken, or pen marking.
yes. Ball,
Ball pen. Now, what happens is, there are cases in which people don't fill up the full question paper, they don't give all answers, so they have possibility of putting those pen marks, you fill up the holes, you block the holes, or that's a possibility which happens. There's also a possibility of changing the OMR sheet. I don't know whether each OMR sheet had a number. We don't even know that. Was it numbered or not numbered?
So that's not been a matter of inquiry.
1 minute, please. We don't even know how did the checking take place, whether the name of the candidate was camouflaged and the top portion was erased and given for, when it was done for checking. Normally, checking is very simple. You just scan it through the computer and they, with your question answer sheet, and it scans very fast. Doesn't require, it's AI, completely AI. It is. It's not human driven. There's no human checking, except where you want to check. Sometimes what happens is students mark two. They can mark two also, or sometimes you find it's difficult whether it's been marked or not marked. Some whole, the marking by pen is there or not there. The issue would be because the originals are not available. So there is no way we can authenticate whether the original OMR sheets were identical to the scanned OMR sheets which are available on the server.
So the entire inquiry has,
But then how do you, if this is the position, then what is the fault in the finding of the High Court?
no, the submission is this, Lord, that High Court proceeds on the authenticity and legality and validity of the OMR sheets.
No, they do not. Please understand one thing.
No, that's how, Lord, the.
No, Mr. Devedi, that's not, that's why I said there's a difference between 65B certificate. 65B certificate only says that the hard copies which have been downloaded or which are downloaded are the copies, is the copy of the.
No, I'm not on 65, I'm not
that's
on
what-
I'm not on 65B.
But it will not prove that what is scanned and stored in the hard disk is the original of the OMR sheet.
But that's how the High Court proceeds. High Court, Lord, takes the OMR sheet and gives it to the SSC and others and to find out, Lord, on the basis of comparison. Because the marks obtained by the candidates selected and appointed are known. Now, based on the OMR, High Court finds out that the person who got 0 to the OMR sheet recovered has got, Lord, higher marks. So that's how they say that marks have been interpolated for that candidate.
Okay.
So the basis of the
Anyway,
entire,
we have put that question. Let's see what answer we get.
yes. My respectful submission is that the
Okay,
basis,
let's read further from 325.
yes.
Then there is 771, 783 and 1741, whereas the details given in the CBI are much higher.
But there are small differences, we have reconciled it subsequent.
There's,
More or less same, will come if all the three.
no, that table doesn't tally. This one which are found by the CBI, they don't tally with the OMR issue. Then there's a rank jumping. And then there's alleged irregularity. What do you mean by alleged irregularity?
That's the sum. OMR plus rank jumping.
That's the sum total of the two?
Yes.
Extra is what? Room and X is the same.
Okay, fine. And then there is the case where additional or excess appointments have been made.
Yes.
Irrespective of the marks obtained,
Who are beyond the list.
beyond.
So what I'm trying to respectfully submit, Lord, that the two authorities have been able to
Look,
identify.
now the factual situation as it is emerging is this. SSC did not maintain the mirror image. The original OMR sheets are not available. The only evidence with regard to the OMR sheets which are available is in form of scanned OMR sheets, which was done by data and then given to NASA. There is evidence to show that the marking or the marks obtained as per the scanned image of the available with data is different from the marks which were entered in the server of the West Bengal Civil Services. There is also, as far as appointment of NASA is concerned, there are irregularities stated. The scanning itself, the process followed, there are irregularities stated. Because data did the scanning purportedly in the office of the SSC. But we don't even know whether the scanned images which were done by data, there are the actual scanned images which were recovered in the form of the hard disks. We don't, 1 minute, please. We don't even have that because 65, please. 65B certificate will not say so and will not be able to authenticate. 1 minute, please. Because then you had to lead evidence to also show that the hard disks which were recovered by the CBI were the actual hard disks which were installed in the machines or the scanners.
Yes, that is established.
That is going to be difficult. That's going to be very difficult for you to establish. Number two, the metadata in then those scanners will have to be examined to find out whether there was any change in those. Because metadata will give you the date on which it was scanned and uploaded.
The CBI has done.
1 minute, we'll know from the
Extensive-
CBI, we'll ask the CBI whether they have done that, we'll know exactly.
They have done
One
extensive.
minute. Now, which the High Court failed, if these are the facts on record, we cannot now segregate tainted from the untainted cases. Now, meet all these arguments which have been addressed in your own way, and other petitioners can also meet that argument in their own way. We'd now like you to hear you on that, and
So,
then
Bruce-
on the second part with regard to the CBI.
So, bro, the record which is with.
No clear finding.
In the Supreme Court, January.
Clarification we require. The details of all OMR sheets were found, details of all OMR sheets of the candidates who had
Appeared.
appeared were found in the server, or there was some missing.
So I think.
May I just such.
There seems to be no finding that these
Honorable
three
Court
hard
directed
disks.
everybody to inspect.
Please hear what I have to say, then you answer. There's no finding anywhere in the judgment that these three hard disks which were recovered contain the OMR data of all the candidates who had applied and appeared for all 4 categories of posts. They did contain, those 3 hard disks contain the entire data. There's no finding available anywhere.
Because just to satisfy the court's
The
query,
CBI also doesn't say so.
order-
65B certificate.
that the honorable court directed,
It says, Pankaj Bansal, from whose custody these 3 discs are obtained, says all data, including the scanned images of OMR.
His saying so is not sufficient. Where is the comparison with your OMR evaluation marks data, which is at least available still with you?
Because our server.
On that basis, do you say anywhere that entire data is available? You don't say so anywhere.
Very small discrepancies, there are nothing.
No, we'll hear you, we're not saying. And one more thing which has been mentioned in the High Court judgment, that there was some blank OMR sheets.
yes, fact.
Is that correct?
Yes.
The
Were there some blank OMR sheets?
report
also?
doesn't, CBI doesn't say that.
That is the affidavit of SSC itself, I show.
And there is a notification also.
Okay.
The public, the
So
public.
these are the issues, you have to now meet those issues.
No, but listen, with respect.
Another
to
important,
Rather not issues, rather these are facts which.
Yes, yes. And,
another important aspect, may I clarify, just for,
Let them finish, then you will have it.
deeply obliged.
So, Lord, in greater detail, Lord, this aspect will be dealt with by the commission, Lord, but I am, my Lord, submitting, my Lord, on a narrow footing. namely that extensive inquiry had been done, one by Justice Bag's committee, my lord, which was appointed, the other, my lord, by the
Tell me why did you create supernumerary post? Why did you?
Yes.
What is the purpose of creating that?
supernumerary post, my lord, because after Justice Bag's report was received,
When was that report received?
uh, just, which year? In April 22.
The report was received after the report said there were irregularities?
Yes, they also found some irregularities, but not as extensive as the CBI report. It was on a narrower. Based on which, my lord, 269 appointments had been invalidated, which then came up in the interim stage to this court. Your lordship stayed the.
So they found there were irregularities committed. So in order to deal with that situation,
So, my lord, we.
instead of weeding out the persons who had been appointed illegally, you said, okay, create supernumerary
So
post.
for appointing the
No, but
wait
then,
list.
Mr. Devedi, tell me
Wait-
one thing.
wait
If you find irregularities committed, will you not throw them out first?
No, not for them,
But 1 minute,
for
But-
wait listing.
1 minute. The moment you create supernumerary posts, you are was then ensuring that the persons who are tainted and wrong, who should not have been appointed, their appointment should continue.
No. The order specifically says for appointment from the waitlisted candidate.
Correct? For the reason is this, that you don't want to throw out the tainted candidates.
No, my lord, sir, that is not up to us because High Court says, my lord, they have to be non-ordinary. We can't retain them.
Okay.
We can't retain them. And we specifically said that this is subject to orders of the High Court. And we did not appoint anybody. Equally, more so, my lord, this order was challenged in some other petition which is still pending in the High Court, where an interim order was granted staying that
Narayana,
order.
Wi-Fi is on.
And
Wi-Fi
it is being pointed out in 306 is the SSC had taken the stand that they have the mirror images with them. In the affidavits which were filed and when the OMR sheets were supplied, it says the affidavits filed by the
January
petition.
24 also.
Sorry, my lord?
In January 24 also.
Yes.
That the database was stored in SSC database, was supplied with a sheet on so-and-so from the SSC from its database. And again, from its database. So if they were giving data, the OMR sheets from their database, where did their database of mirror image go?
That's not our affidavit.
And you come to this, that's the one finding, and then you can come to page 305, which is the report, which quotes from the report. Let's read that part also.
I can place the whole of.
These are your affidavits filed by the SSC. And the SSC in the response to the Right to Information Act said that OM sheets to individual claiming that data was in its database. That's the finding recorded. The SSC had in the RTI application said that the OMR sheets copies are available in its database. And the affidavits filed with them again say that the OMR sheets are being given are from their database. Whereas now the stand taken by the SSC is they don't have any database of the OMR sheets.
Those who are in the 13,000,
We have understood.
those who are in the else,
Yes.
that's it, my lords. And therefore, I'm only submitting, and my suggestion is only this to your lordships. Please, my lords, mold the relief accordingly based on who is in which category. But surely people whom SCC has not found have to have an opportunity at least, if nothing else. I'm not saying for everything. I'm not pleading natural justice. I'm not pleading, but surely it can await some judging of that evidentiary content. That is all I'm saying, my lords, nothing else.
My lord, I will submit that, my lord. Kindly see section 45A of the Evidence Act. This certificate is not there. Section 45A of the Evidence Act speaks about when in a proceeding, the court has to form an opinion on any matter relating to any information transmitted or stored in any computer, resource or any other electronic or digital form The opinion of the examiner of electronic evidence referred to section 79A of the Information Technology Act is a relevant fact. Now, my lord, the section 79A and section 45A, 79A of the Information Technology Act and section 45A of the Evidence Act were not amended on the same day. And section 79A of the Evidence Act says the central government may, for the purpose of providing expert opinion and on electronic form evidence before any court or other authority, specify by notification in the official gazette any department, body or agency in the central government or a state government as an examiner of electronic evidence. Now, my lord, this has been done there by the central government. Different laboratory has been established. Now, my lord, there is no certificate first for the formation of opinion or the taking into it the relevant fact. My lord, section 45A of the Evidence Act, my lord, it has not been complied with. My second submission would be, my lord, if your lordship see the
What
certificate.
they say is this is a relevant fact. It doesn't give the mode of proof page. It's a relevant fact. What is the difference between a relevant fact? Relevant fact means it's a relevant for the purpose of adjudication. Evidence Act also doesn't apply to writ petitions.
No, that's
Let's
correct,
not-
my lord.
Let's not go around in a tangent.
But my lord, the earlier the judgment,
Please.
earlier the order which has been delivered by this
He has
court, my lord,
understood that.
there the Evidence Act, my lord, has been, my lord, the.
Please, Evidence Act
Now,
doesn't
my lord,
apply.
kindly just, my lord,
There are provisions of Evidence
65
Act which can be taken into account, but it's not firstly applicable.
my lord, 65B4.
Here the CFSL report has been obtained. It's a,
Not
relevant-
obtained.
all that it says is a relevant fact. That's it.
It has not obtained. It has not been obtained.
1 minute, CFSL report has been obtained.
Not,
No,
no,
it's
it
not
has
been
not
obtained.
obtained. It has not
There's
obtained.
no FSL.
CFSL report has not been obtained.
I think forensic examination of the, has been done. The mega data has been there. Is there, you're wrong on that.
My lord, it has not been obtained, my lord, kindly.
It has been obtained. It was sent to the forensic examination in Calcutta. That report has.
My lord, it has not been recorded, declined. They have declined that they would not do it.
Okay.
It's
CFSL
not-
Hyderabad declined, not Kolkata.
Pardon, my lord?
CFSL Hyderabad declined.
That's
Thereafter, it seems to have gone to Kolkata
My
CFSL.
lord, thereafter, not in any other laboratory, it has
The
not.
finding that the hard drives have not been contaminated.
Thereafter,
That was read
it has
out
not,
to
been-
us.
it has been not sent to any other laboratory.
Okay, fine.
Why not? Next-
Please, there's a difference between a relevant fact and admissible.
That's right. My lord, kindly say the second point.
Experts are never the only way to prove.
My lord, kindly say 65 2B4. 2B4 speaks about who will, my lord, give this certificate. Not everyone. My lord, kindly say this, I am coming to very relevant portion. I am not reading in 65 4BC.
The one who downloads gives the certificate.
My lord,
The one who downloads gives the certificate.
no. My lord,
Yes, that's the law.
it has not purporting to, kindly, my lord, just excuse me, my lord.
We
Kindly.
have read
My
65
lord,
B so many times.
I understand, my lord. Kindly excuse me, my lord. Kindly excuse me. The convention in its subsection to relate as purporting to be signed by a person occupying a responsible official position.
Correct.
In relation to the cost.
So from whose possession the CDs were recovered? The hard disks were recovered? From whose possession were hard disks recovered?
Data entry operator, according, but kindly read this CBI report, whether Pankaj Bansal's name is mentioned there.
Okay, fine.
Blood, the two other persons, blood, who are the persons who in charge of the operation? They were there. Certificate has not been obtained from them. Certificate has been obtained from a person who has left the company and went to someone. This is there from the report itself, Miller.
Not even, in fact, 65B certificate is not required because it's the original document here, the original hard drive which has been recovered.
No, it's not an original document.
It's the original. That's what they are saying. It's the original.
This is not an original document, Miller. It's an image. OMR sheet has.
1 minute, please. It's not required. Suppose email comes to you. Email comes to your computer and you produce your laptop or your hard drive in the court.
That's an-
65B certificate is not required.
That's an original.
That's good. That's law. The next case, please. Next argument.
My lords,
Yeah,
very
I-
briefly, on the point of originality, my lords.
Okay, one by one.
Permit me.
My lords, just a very brief point on the point of originality.
No, dark.
My lords, the OMRs are essentially
No, Dave.
a sheet with dots on it.
Not
Now,
the-
SSC
there
to
is
OMR
generational
are
loss.
there in the
the
compilation.
round markings, dots are given by.
OMRs are in the compilation.
Precisely, my lords. Now, my lords, then what happens?
1,000 pages that were given to us yesterday. OMRs are there.
This is at page 2826 of
One
volume
one two eight.
5B.
One,
Volume 5B, page 2826.
Volume,
five,
5B,
2826.
2826.
we don't have volume
2A.
5B by the way.
Yes, my lord, it has been given.
It's a very
There's
short.
no volume 5B in the compilation which was given.
We've all been waiting.
2826 of compilation miscellaneous volume 5B.
must be paying, now they must have changed the number.
2826.
But which page
2806
of it?
also.
2806 miscellaneous volume 5B.
Just scroll it, just scroll it,
Yes.
What is this?
2806.
scroll it. Scroll it.
My lords, so while they find that, the OMR, as my lords may imagine, we've all done multiple choice tests. That is the version of the email.
How then?
Now, what is the hash value that they have compared? It is not the hash value of every individual OMR. What they are saying,
They cannot.
that they, okay,
It will be impossible. If they would have done that, because probably the scanned documents must be contained in one file itself. And the hash values would have come when they checked it up. What they have done is they compared hash values of two hard drives. We know when the CBI counsel tells us whether the hash values included the date on which they were scanned, etc. or not.
from the metadata, as my lords had requested them. But my lords, when they extracted the data from the OMR into a .dat file, there is, and I researched this extensively, across the board, there is admissions that there are generational losses. So for example, just to put it quite simply, when in, not today as much, but in 2019 or 2018, we used to convert PDFs into Word files. There were errors. Now, my lords, what they've done is that they have got these response strings that they themselves created. And then you have these hash values with not one generational loss, but two, because there's the .dat file that then becomes the .dbf file, a third file. And then you compare the hash values, my lord. And so the thing is that
You are supporting complete, you are in other words supporting the complete obliteration of the result.
no, my lords, what I'm saying is this. What I'm saying, my lords, is that of course all may not be well in the state of Denmark. Of course.
You
That's
belong
just
to
a
which
parent.
class? Class C and D, A or B?
I'm in 9th and 10th.
9th and 10th, C and D,
No, not C and D. C is clerical.
Non-teaching.
not teaching.
I'm an assistant teacher in C and D.
Okay, 9th and 10th is the.
I'm 80 assistant teacher.
Tainted, not tainted.
Tainted, not
Tainted or not tainted?
My lords, I believe I am not
Not,
tainted.
not your belief. As per the order, do you fall in the tainted category?
My lords, as per the order, there are three types of tainted. And all three types of tainted are based on entirely different evidence.
Are you there?
So I am there only
One of those.
third category. So when we look at the
The
first,
third category, you got to jump in marks.
where the OMR is being challenged. So my lords, what we are saying, my lords, if I may just point to the differential in the value of the evidence between the people who are
Then
alleged to
wonder
have
which
jumped
way
ranks.
What's, we can break up any argument, even on pure facts or truth. Please don't do that.
But my lords,
Don't do that.
but my
There are
lords
certain-
raised a question earlier, if I may.
There are certain things which are quite apparent, let's not argue. it.
But my lords, the things that are apparent, the ex facie
Your
wrongdoing with the
The
rank jumping.
sheets are there, the sheets are all there, the names are written, everything is there.
For the
Well,
top of the document.
All I am saying, let it face
Let's assume something-
process. Let it go through some process. Either the criminal process, this Pankaj Bansal is going to fall under cross-examination. Or my lords, let it go through the 2018
That's not the
rules.
way writ petitions are decided.
I beg to appear for the non-tainted category.
Right.
I mean the non-tainted.
First, let's deal with the tainted category and then.
I
we
just
go
want
to
to make a
non-tainted.
very broad submission.
Then your lordship can deal with that partly tainted or tainted, then
Not,
I will.
not as per your belief, as per the judgment if you're tainted.
Untainted.
Or not.
Lords, maybe get back when the CBI comes back with the metadata. Maybe get back to my lords on this.
for us to be.
I'm grateful. I'm grateful.
We are in the untainted category where there is no taint.
Malaz, may I just,
Whereas in 4 years, would the CBI put me in some list? Would the board put me in some list? Would the SSC put me in some list? Whereas I can't prove a negative, Malaz. They've been doing lists for the last 4 years.
Malaz, just I'm appearing in 1.11. I'm in the same category as Dr. Singhvi's client. Malaz, I just one small submission break. It'll take 30 seconds. Malaz. And that is that the CBI has got, Malaz, the material from the hard drive. Having got the material, they have segregated themselves because they have, Malaz, said that 92% in 9 to 11 are not tainted, but 8.24% are. And as far as 11 and 12 is concerned, 14.57 are, 86 are not tainted. So the CBI has done that exercise. And having done that exercise, then, Malaz, we can't be punished. And I'm in the same category. And the writ court, what it does is it takes C and D category, the other category where it is 30% and 40% tainted, and clubs it together. Instead of, Malaz, the 19,000 people, of 19,000 people, 8% or 14%, Malaz, take an average of 12% are tainted. You will, Malaz, throw out the other 88%, Malaz, because 12% are tainted.
Please, on that case of difficulty, we have understood your argument because CBI itself has bifurcated.
Bifurcated, correct.
Yes, they have
Lord,
done. That's
Lord,
all we
I am
want.
in the same category,
all,
my lord. I am in the same category as that of Mr.
That's all.
Singhvi and Mr. Sibal, my lord. Only difference is Group C and D I represent, my lord. My SLPs are right on 1.5 and 1.13, my lord. My submissions are at page 100, volume 6A. But my submission is that, like your lordships have noticed, from para 288 till 309 of the impugned judgment, the High Court has taken note of the segregation information that has been given, my lord. In none of the reports that our names have figured. We have been appointed in the first list in April 2018. From then, there is no material, nothing, till the impugned judgment, we have not been called upon to do anything. Our name is not mentioned anywhere else. Now, the point here is, if the High Court holds that the information is admissible and we have got enough information to segregate the names from the tainted ones from the untainted, and if this kind of direction at page 272, para 363, the direction number 4 will say that persons who had been appointed outside the panel after expiry of the panel, as also those who submitted blank OMR but obtained appointments, must return all remunerations and benefits received by them in the state exchequer along with interest, etc. My lord, if this kind of information can be taken and their appointment can be set aside with the same kind of information, my lord, how can the item 2 order can be passed, my lord? All appointments granted in the selection process involved is violative of 14 and 16, so all are declared null and void. So this direction, number 2, my lord, cannot stand because there is enough material with the CBI and also, my lord, in all the affidavits which are placed before the High Court, which your lordships have seen. And secondly, my lord, like Mr. Singhvi was pointing out, my lord, Interpret Singh column really says, my lord, there are 3 tests which I have extracted in para 2.3 of my submissions, which exercise has not been undertaken by the Honorable High Court, which says, my lord, just I'll read this. If the services of the appointees who had put in a few years of service were terminated, compliance with the 3 principles at the hands of the state are imperative. That is, to establish satisfaction in regard to the sufficiency of the materials collected so as to enable the state to arrive at its satisfaction that the selection process was tainted as far as them. To determine the question that the illegalities committed go to the root of the matter which vitiate the entire selection process, such a satisfaction as also sufficiency of the materials were required to be gathered by reason of a thorough investigation in a fair and transparent manner. Whether the sufficient material present enabled the state to arrive at a satisfaction that the officers in majority have been found to be part of the fraudulent purpose or the system itself was corrupt. None of these, my lord, have been carried out. And para 93 says, it is one thing to say that having regard to the nature of the selection process, no person is appointed from the select list as no person has a right to be appointed only because his name appears in the select list. But in our opinion, a different standard must be adopted for terminating the services of the officers who had completed about 3 years of service in that case. Some of them, as noticed herein before, passed departmental tests. Some have been given higher responsibilities. They had completed period of probation and some were nearing the completion thereof. They presumably had been working to the satisfaction of the authorities concerned. Same here, my lord, from 2018 we have been continuing in group C and D. No action against us, my lord. Till date, no names have come out, my lord. We have all altered our position in the society. We have improved our lives, my lord. Our lifestyles have changed. And we have, some of them have entered into family and, my lord, created loans, etc. Their rights will have to be protected since they have not been, my lord, a part of any of this. Even, my lord, in para 2.5, my lord, at page 100 of volume 6A, the judgment in Rajesh Putanvalli Kava, will say that, my lord, is of significance. If somebody submitted, it's not a case where massive fraud is said to have permeated the entire process since its inception or in the conduct of the examination itself. Furthermore, the untainted candidates, including the petitioners, stand to lose their job after having worked for 6 years without, compliance of Article 311 as
Okay.
such, my lord.
My lords, I appear for the,
There was a bad committee.
my lords, I appear for the,
There is.
He has been standing on his legs for.
I only praise, just one thing, para 3.3,
My
my lord.
arguments have been raised, not only
Right.
small.
This will give,
section there. not
create-
that's all.
You have understood your argument.
my lords, I appear for the,
since the material is already.
my lords, I appear,
At best, my lord, there can be a committee which can be appointed if your lordship so desire, my lord. I have just suggested.
Can I say
para
something?
5.1.
I'll not repeat it.
A committee of the retired judge of this honorable court with a technical expert from NIC.
Okay,
Some
okay,
retired
fine.
member from. the
Okay,
case.
fine.
I'll take only 1 minute.
But our appointments have to be protected is my
The
prayer.
untainted category which Dr. Singh addressed your object of, there are 1,800 people approximately out of 12,000 who have actually given up government jobs and come here. And so our written submissions are at page 49 to 54 of compilation C. So, my lord, please see the inequity for us. Untainted, not in any list, not named by anyone, and given up government jobs to come to better our career prospects. And now we are faced with this difficulty.
my lords, I appear for the, if your lordships will permit me.
Just 1 minute.
Yes.
Can I? Can I?
Let Mr. Deveni.
My lord, in a similar manner.
Let Mr. Deveni wants to argue, then we.
Most of my arguments have been covered, so I won't repeat. My only point was that kindly have just para 3 and 5 and 2 paragraphs of that report, and I'll show note this concept of mismatch, which now is the center point of debate here, not is wholly not the baseless. Lordship may kindly have para 3 and 5.
3.305.
305. Investigation has established that the scanning of OMR sheet was undertaken by the said Ms. NISA Communications Private Limited, at the office of the SSC, Acharya Sadan, under direct supervision of Shri So-and-so, Niladi Das. Lordship, omit the rest, kindly come to 5th line from thereafter. After completion of the scanning,
Yes.
the processed data in the form of scanned images of the OMR scanned data, etc., were handed over to Messrs. Data Scantech, handed over by Messrs. Data Scantech Solutions to to NISA Communications Private Limited, who took the same to their office located in Noida in digital form, leaving the original hard copies of the OMR sheets in the office of the WBCSCC, handed over their answer keys in respect of all subjects to NISA Communications for evaluation of OMR responses. Now, bear in mind, Lord, NISA was never a party anywhere, nor was it raided ever time, nothing was recovered from them. Now,
10th of January, my lord.
Okay.
10th of January on the top of the board, my lord, because your lordship's order for 1 year has not been honored.
Item 42 has some urgency, my lord. Could your lordship
That matter, what?
But it is a CIRP matter, where Lord CIRP process is permitted to go on subject to the result.
No, we-
My lord, may I just submit one?
January.
January, I'm asking for actual date, January.
No, 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 it will remain on board.
My lord,
January, let me put it now.
It's 42 today.
Let me just, Thursdays will become a regular day now. Thursday, Monday, Tuesday, Wednesday will be maintenance.
I
Thursday.
see.
So this will retain its
But-
position.
We're going to be circulating, there's some work which has been done with regard to the after notices, regular matters, along with the office note.
Right.
A brief note about the case will be there.
I see.
My lord, may-
Thinking, my lord, 42 is
my lord, I appear.
lower in the list, but can we request for your lordship?
Let it remain, let me just wait.
Grateful, man.
It's just quite an visited fixed.